I invite Justice Anand Venkatesh to commence the deliberations. Sir, please, sir.
Yes. Good morning to you all. It's again a great pleasure to be part of this webinar series. It makes it even more special for me because this is the first time I'm sharing the platform with retired Justice Vimala. So it's a great pride for me. And I'm also happy to have an young participant whose opinion on what we are going to discuss today will reflect the real status as it prevails on the field today. So therefore, this is going to. I hope that this is going to be a very, very interesting discussion, and I want all of you to pitch in with your views ultimately or your questions. So with this small introduction, I would start the deliberation. See, the irretrievable breakdown of marriage as a ground is being recognized by the Supreme Court repeatedly, at least from 1985 onwards, if I am not wrong. So this is something which is being recognized by the Honorable Supreme Court, and every time what happens is that ultimately they end up exercising their jurisdiction under Article 142 of the Constitution of India, taking into consideration the particular facts of the case, and in order to do complete justice, the marriage is dissolved on the ground of irretrievable breakdown of marriage. So this keeps happening every time. And even in 2019, I was able to see one judgment in Monish versus Nidhi in 2019. Again, where they have done the Honorable Supreme Court has reiterated the position, but ultimately, when you come to the penultimate paragraph, you will find that the Honorable Supreme Court would have exercised its jurisdiction under 142 and dissolved the marriage. Such orders can, as you all know, can never be taken as a precedent, and no High Court can say that Supreme Court has declared it and therefore I'll follow it. 142, as you know, will apply only to the facts of that case. It cannot even be taken as a precedent by a subsequent bench of the Supreme Court. So therefore, this has been troubling me for quite some time. And I thought that this really requires a debate. I'm sure that there are many platforms which are debating this, but I thought that I can make use of this webinar series, which is being attended by honorable judges, senior advocates, sharp young advocates, where ultimately there has to be debate, there has to be deliberation, there has to be awareness. Only then at some point of time we will be able to see the result of it. So I thought it's very important that there is a deliberation on this in this webinar series. So I had put this idea to Mr. Srinivasa Raghavan, and he readily accepted and agreed, and now the panel is also formed. Before I commence, I would want to request all of you, including my co-panelists, that we need to focus upon this ground without taking into consideration that there is a child there for those spouses. See, if there is a child, then the consideration completely takes a different turn altogether. So if we start going into it, I don't think we'll be able to focus on this ground per se. So I thought, let us not take into consideration a scenario where there is a child for the couple, and thereafter this ground comes. The consideration completely changes because the welfare of the child starts getting prominence. And so therefore, my request to the panelists and also the viewers and listeners of this, to focus on this ground per se by keeping in mind that this is who is available is only the couple, and there is no child for them. So if we do that, I think we'll be able to really get deep into it and we will be able to really develop it, failing which the child will get into prominence and there will be an issue on that. So my request is that let us focus this way. This is my request to the co-panelists and all those who are listening to this. See, for more than 2000 years, Thiruvalluvar in his Thirukural in Illaraviyal has spoken 10 kural, 10 kural on goodness of a wife, and he is given the center stage for ensuring that the family unit is preserved. That is how it all started. So Thiruvalluvar basically defines an ideal wife, and he gives two important functions to a wife. One is, he says, a wife has to maintain the dignity of the home, and a wife has to live within the means of her husband. So these are projected to be two main characteristics which are required for a wife who was in the center stage for the purpose of preserving this family unit. This role of a woman over a period of time has drastically changed. What is important is that, as you all know, and we keep talking on a daily basis, that the law must be a living document. It has to change itself through the changing times, and it should never remain static. So what becomes important is to recognize whether what was prevailing 2000 years back or 100 years back is the same situation that is prevailing now. If that is not prevailing, then it is very important for us to see whether the existing law is in a position to handle this the situation, or it requires either an amendment, or it requires a loud thinking. It requires a lot of innovation on the part of the judge to read certain things into the prevailing law and grant the relief. So these are broadly the things which I wanted to focus on. Today, as I was telling you, the woman has got into a stage where we have given her a dual responsibility. One is, she continues to take care of the domestic course as it was happening earlier. And there is another important component that has come into the life of a woman, which is her career. The career which was never used to be recognized at all. And it always used to be thought that it is the man who goes outside and earns, and it is the woman who remains inside and takes care of this family unit. It has now completely changed. What is happening is that the man continues to go out and earn, but he is not partaking in what is happening in the house. Therefore, there is an additional burden that has been put on a woman, where there is a dual role that is being played by woman, where she takes care of the house chores and she also has to take care of her career. So that's the situation that is growing fast. So what is a marriage? And is it possible that a marriage can be dissolved? Today the answer is very easy, but earlier the answer was very, very difficult. See, the marriage as an institution is the most fundamental unit of the family and the societal life. What does this marriage mean? See, the marriages are made in heaven. That is how we started. So therefore, this was something which was made in heaven, and therefore, if two persons marry, then the only thing which will dissolve it, the only thing which will put an end to it, is the death of either one of them. This is how initially the institution of marriage was conceived. So the marriage was thought to be an indissoluble relationship between two persons. So basically, what are we talking about? I read or heard somebody saying that marriage is two persons getting into a golden cage and locking themselves. Thereafter, they throw the key outside. So what happens is that these two persons will have to remain in that golden cage right through. Whatever may be the understanding, whatever may be the problems, they have to. This is how marriage was perceived when it started as an institution. So both in Hindu as well as in Christian marriages, I find that this was more considered to be a sacrament which can never be dissolved. That is how the institution of marriage started. This concept slowly changed, and the laws started facilitating dissolution of marriage. That is how it started. The Hindu Marriage Act, the Christian Marriage Act, the Indian Divorce Act, etc., etc., etc. All those laws started facilitating dissolution of marriage. As you all know, the marriage can be declared as void under certain circumstances, or the marriage can be dissolved on certain grounds like cruelty, desertion, conversion, etc., etc., etc. I will not go into all those things because all of you know about it. So, what is a court concerned about? A court is not concerned whether the couple is living happily or not. The court is not concerned about whether the couple are living a satisfying marital life. The court is only concerned about whether the facts that have been put before the court is able to be fit in any of those grounds which are available to either declare this marriage as void or dissolve this marriage. That's the only function that is expected of a court in the present legislative setup in Christian law as well as in the Hindu law. So basically, to start with, divorce was a word which was frowned at. People will not even, they felt that it's some bad omen to even utter the word divorce. It was thought that it goes against the very ethos of the society. According to me, this is my personal opinion, this ethos, according to me, is founded on the sacrifice made by a woman. So from here on, I'm taking my part and I'm going to say what I feel about it. See, basically, men were permitted to marry more than one. Bigamy was recognized. And 1956, before 1956, it was recognized. There were bigamies happening. There were extramarital things happening. Everything was happening. So the role of a wife was fixed, whereas the role of a husband was, it can be in a flux. It can keep changing according to times, etc. So this was happening, and 1956 was a time where the change took place. What is marriage? It is true that people say that marriages are made in heaven and all that. But what is marriage? Marriage is a voluntary decision, according to me, is a voluntary decision by two individuals who have decided to marry each other. This is an individual decision. Now, I will slightly sidetrack and talk about friendship. It's important that you appreciate what I'm going to say now, because ultimately, when I end my part of the discussion, I'm going to pitch it on something in line with friendship. What is a friendship? See, in a friendship, my dear friends, I love to say that friendship was given so much of prominence again in Tirukkural. In Tirukkural, in Poruppal, you will find 10 Kurals only on friendship. Only on friendship, and it has been given the highest level of the relationship has been taken to a very high level. Where in one of the Kurals, the Thiruvalluvar says that true friendship is not mere smile between two persons, but a smile in the face, but it is something which is felt deep within the heart. So it involves a relationship where there are two hearts which are coming together, like in a marriage, in a friendship also. So, if two persons become friends, there is no compulsion for two persons to become friends, to become friends. Then there is no law governing friendship. It is open for those two persons to remain in friendship and get out of friendship also. So when it comes to friendship, you will find that there will be the same love and affection. There will be the same misunderstanding. There will be the same tantrums being thrown on each other when in a given situation. There will be the same separation between two persons who are friends. But ultimately, in our life, we have always seen for centuries together that the true friendship subsists till the end. Till the end. And this is happening without a law governing friendship. Please have this in your mind. There is nobody compelling somebody to be a friend to somebody. So, in a friendship, ultimately, when situation comes to such an extent where they want to part, they peacefully part. It does not mean that from the day when they have parted, they both have become enemies. No. They have tried their best. They have come together, and at a particular point of time, they both feel that their thinking is different, their whole outlook is different, it may not work. Therefore, they say that let us part. In fact, there is this famous expression, let us part as friends. You would have heard it so many times. So, keep this in your mind. Keep this in your mind. You will understand what I'm going to say henceforth if you have this idea in your mind, and you'll be able to appreciate what I'm saying. So, after, as I said, initially the law started recognizing certain grounds for the purpose of dissolving a marriage, and that hard stand that marriage can never be dissolved, this word divorce is frowned upon, etc., started diluting because there was a change in the society. So therefore, law felt that we must create some grounds to ensure that two persons who will not be able to continue as husband and wife will have to be given some opportunity to dissolve the marriage on certain grounds. The next improvement that took place is dissolution by mutual consent. This, according to me, was a real development of law, which is under section 13B of the Act. So, here what happens is that even if the party, where two parties feel that enough is enough, we will not be able to get together. Let us not wash dirty linen in court. Let us part. The law opened up and brought in an amendment, and slowly the dissolution of marriage happened through mutual consent between the parties. Why? This was a societal need. That is why the law acted and brought in this ground. And the parties themselves agree that enough, we will dissolve the marriage is not working. Of course, time is given for contemplation, that 6 months time, etc., etc. I will not go into it. I'm only saying that there was this march of law that takes place after the coming into force of the original act. Then, again, the concept of marriage is changing drastically. Drastically, it is changing. See, go back to why it started. See, earlier, why is that they wanted an institution of marriage? They wanted it because it was a societal need. It was a societal need. What was thought was these biological urges, these carnal urges, these physical urges will have to be satisfied. And this must be met without breaking this concept of morality in the society. So, it became important to discipline it by fixing a man and woman into a relationship where all these urges on both sides can be satisfactorily done, and and it will not also cross this boundary of morality. This was one. Then it was thought that if the earth has to survive, there has to be human beings here. Therefore, progeny or child being born through these two persons became one of the most important factor in order to continue with this institution of marriage. Then what happened? Then what happened was that duties were clearly assigned, where the wife has to take care of the parents, he has to look after the children, she has to do the house chores, and she has to be a partner of the husband. So basically you would have found that there are only two rooms to which a wife was almost confined. One is a kitchen and the other is the bedroom. These are the two rooms over which I would say she had a domain. So today we are slowly crossing this also. See, today the marriage as such is being looked at more as a partner for each other. It's with bonds of friendship. That is how the marriage as an institution or the marriage as a concept is being seen today. I will repeat, the marriage today is looked at more as a partner for each other. Two persons being partner to each other with bonds of friendship. Partner, friendship. This is how it is rapidly moving. My question is, was it not available even earlier? Each one of you will have to answer it for yourself. Each one of you would have seen the society at large. You will have to see and you will have to answer it. Are spouses actually maintaining friendship? Can anybody boldly say that we are the best friend? My wife is my best friend. My husband is my best friend. Whom have you seen saying that? It's a very, very low number. It's a very low number. So, therefore, this partner, this friendship, this bondage was supposed to be there even in the earlier relationship. But due to various factors into which I don't want to go, I am just touching it upon. That's why I don't want to get into a debate on that. I'm only saying that the important factor of friendship was something which was missing in many marriages, in so many marriages. So, marriage was as an institution working only when the women were willing to sacrifice her own wishes and her own dreams. And I would say without any hesitation, this is again my view, I would say without any hesitation that marriage as a concept, as an institution, was working only on the sweat and blood of a woman. So the society therefore is now changing. The society is now looking at marriage as I told you, as a relationship, as a friendship, as a bondage of love and affection, as a mutual dependence between parties, etc. That's how it is moving. So, under such circumstances, the issue is when this bondage, when this friendship, when this mutual love and affection breaks beyond repair, then is it necessary that in spite of it there must be forced bondage on them? There should, the forced bondage should continue. Shouldn't the parties be allowed to walk out of it without washing dirty linen in the court? The reason why I am bringing this is that the marriage today can be dissolved only if you are able to fit in the facts of the case to any of the grounds that have been enumerated under the Act. It can be the Hindu Marriage Act, Christian Marriage Act, Indian Divorce Act, whatever it is. So, for the purpose of fitting in the facts into the ground, I find that there is a lot of imagination on the part of the, I'm sorry to say, on the part of the advocate who is drafting it. So there are lots of things which get into the petition, those facts, seeing which the wife herself will be surprised. She will find that there is a huge play that has been written by one of the advocate by adding one para to the other, wherein he wants to bring it within a ground that is found in the grounds that are found that are provided by the Act. So what happens is that in the given facts of the case, if it is not going to really fit in, then imagination starts playing. That happens even in the criminal proceedings under 498A. See, what we must keep in mind is that the increase in the number of criminal complaints pertaining to family relationship is because of the failure to properly manage a dissolution of marriage on the civil side. It is a proven fact that where there is a failure on the civil side to handle the situation, you will always find an increase in the number of criminal cases. It is automatic consequence. So therefore, in every 498A, you will find words like our dinamum, our ammavin kale amikki vida sonnar. These are all standard things which you will find in a 498A case. I'm not saying every case is false. I'm only saying that this exaggeration on the part of the parties, the exaggeration on the part of the advocates is coming into the fold only because we don't allow the parties to dissolve the marriage peacefully, and what is allowed is to bring it within a ground, and in order to satisfy the ground, it actually aggravates the whole situation, is the way in which I am seeing it. Now, I see that there is a clear writing in the wall that this will change. My loud thinking is, Article 21 of the Constitution of India guarantees right to life that has been recognized by judgment after judgment. Sometime later, after so many years, not now, but sometime later, it is possible for a spouse to contend that you cannot compel me to have a friend, you cannot compel me to have a spouse with whom I cannot live. By compelling me to live with him, you are violating my happy life, which is a violation of the right to life under Article 21. Today, what I am saying, many of you may be surprised with, you may be thinking that I am exaggerating. I am not exaggerating. Article 21, as it remained in the Constitution, was remaining so silent. See, 30 rights have come out of that article today. So therefore, at one stage, you will not be surprised if somebody says that if you compel me to remain in this bondage, by compelling me to remain in an unmarried, in an unhappy married life, my right to life is being affected. So therefore, you cannot lock me up for my whole life because by compelling me to live with a person, that itself will amount to my right to life or my right to lead a happy life. It may go to that extent also. So today, how is it looked? It is looked as equal adult partners is how the marriage is being seen today. See, it has become more a functional arrangement. It has become a very clear functional arrangement, and the dissolution of marriage, which started with these grounds, which I call as fault theories, cruelty, desertion, etc., which moved to mutual consent after some time, has to necessarily now recognize irretrievable breakdown of marriage also. Look at this. The amount of time that is being spent by the young spouses in courts, in family courts, is shocking. It is shocking. The judge who sits in a family court, I am sure, will be drained if he is to handle such cases on a daily basis. It all started with one family court in Chennai, and today, if I am not mistaken or wrong, I think there are now some 7 family courts. So it's all crowded. It's all young persons flocking there. And they spend a lot of their very important time in their life in court for the purpose of getting the marriage dissolved. So, as I said, for the purpose of meeting it, there is a lot of imagination that goes in, a lot of allegations are invented. So these exaggerated things, what happens is that the heartburn increases, the animosity increases, the mood with which both of them initially came to the court will be completely changed thereafter, and it will have a disastrous consequences on their respective families. So the question is, should the marriage be preserved? The marriage as an institution should be preserved in this manner. Should spouses be tied up when the marriage relationship itself has become incompatible? Should not the law provide for an exit route, easy exit route, reasonably easy exit route, when the marriage has actually become a deadwood? So, for instance, parties who just lived for 2 months, thereafter separated for 5 years, 6 years, where is the emotion in it? Where is the bondage in it? Where is the friendship in it? And on such marriages, we try to seriously try and find whether any grounds are being made out. It is a deadwood. If it is a deadwood, why would you require a ground? It should be knocked off on the ground of irretrievable breakdown of marriage. So, if you look at how law has progressed, you know the judgment of Justice Chinnapareddy in 1985 3 SEC page 62. 1985 3 SEC page 62, where for the first time the Honorable Supreme Court takes note of the change in the society and says that irretrievable breakdown of marriage and mutual consent must be added as grounds. At that point of time, mutual consent was not even a ground. So they say that it should be made as a ground for dissolution of marriage. They recommended to the legislature to make necessary laws, and as you know, mutual consent was brought in. So the Honorable Supreme Court was insisting for a honorable exit of the parties from this bondage of marriage, which is not working. See, thereafter, in many judgments, the Honorable Supreme Court was reiterating this idea. And this one more important judgment which I read was this Naveen Kohli judgment. Naveen Kohli judgment, all of you would have cited it whenever you wanted to establish the ground of cruelty, etc. But Naveen Kohli judgment was again a case where the Honorable Supreme Court recommended. Yes, after recommendation of the court, what happened? The legislature actually acted upon it. It acted upon it, and I was able to find 2 reports of the Law Commission. One report of the Law Commission is in 1978. In 1978, which is the 71st report of the Law Commission, which actually recommended irretrievable breakdown of marriage as a ground for dissolution of marriage. Then the second report was in 2009, which is the 217th report. 217th report of the Law Commission. Again, the same recommendation was made. After this 2009, the legislature acted. What happened was an amendment was brought in, the Hindu Marriage Act and the Special Marriages Act. And in 2010, it was brought in, and irretrievable breakdown of marriage was introduced to be made as a ground. And it was sufficiently provided. If you read that amendment, you will find that it is sufficiently describes what it is, how the parties must be sufficiently provided, how it has to happen, etc. is being clearly enumerated there. This was placed in the Rajya Sabha. It was passed. Thereafter, it was not placed in the Lok Sabha. Legislature, for some reasons which only the God knows, it was not placed before the Lok Sabha. The bill lapsed. With that, it went out. There was no consideration thereafter at all. And for the last 10 years, nothing has happened on this front. It is at this stage the judgment which I was referring at the beginning of my discussion, which is Manish versus Nidhi, was pronounced. Manish versus Nidhi judgment, if you see, it's a classic case of where the marriage has irretrievably broken down. One party will be in Canada, another party will be here. They would have hardly been together for 2 months, and in spite of it, nothing would have improved, and time would have passed by, and it would have become a deadwood. And the Supreme Court, having taken that into consideration, had dissolved the marriage on the ground of irretrievable breakdown, and by exercising 142. Obviously, the Supreme Court cannot be using a ground which is not available there in the Act. So it uses 142. So therefore, what is important is that not all parties can afford to go up to the Supreme Court for the purpose of getting their marriage dissolved on the ground of irretrievable breakdown. That apart, one judge may feel, it all depends on the background from which the judge is coming and his outlook about the society. There may be judges with a free thought, or who think aloud, who may entertain such grounds. There may be a conservative judge who would not want to do this and who would want to stick the letter of law. So therefore, there will be inconsistencies. So therefore, today, the only way where you can do this is that you have to go up to the Supreme Court and you have to get a bench where the judge the judge who is dealing with it is a person who thinks this way, and thereafter he can use an Article 142 and dissolve it. It is almost impossible. It can never be done. So there must be some exit way for a spouse to walk out of a dead marriage which has irretrievably broken down. So, as I said, in a given case, where one of the spouse, both of them had lived only for certain months, and thereafter they have been fighting and nothing had happened for 4 or 5 years. Then when a case comes up and one of the spouse says, one of the husband says that, yes, enough is enough. Let us not continue with this. If you want anything to be provided financially, I'll provide it. Please allow me to go out of the relationship. Let's assume that the wife says, I will not allow you. I will not allow you. I am suffering, you also suffer. If a stand like that is taken, what happens is that it will become very difficult to bring in. That is where the judiciary as on today will have to start thinking aloud. They have to consider these facts also and try to bring them within the mental cruelty. See, mental cruelty has been beautifully dealt with in the Naveen Kohli judgment. And it is possible that this irretrievable breakdown of marriage on the facts of a particular case can be brought within this ground of cruelty also. I'm just giving an example. So if you think aloud, it's possible that you will be able to bring that into a ground of mental cruelty. Can be physical or mental, and you can bring it as a ground within mental cruelty. So therefore, till this amendment takes place, till this amendment actually takes place, the courts will have to play a very proactive role. The higher courts will have to play a very proactive role, and they must take into consideration the changed circumstances, the changed situation, and they have to act in a very innovative manner by expanding the horizons of the available law. And I, with very great respect, feel that in some judgment, the Honorable Supreme Court will have to somehow try and bring this and read it into the grounds which are now prevailing, which are available readily. Only then it is possible that this agony of two unwilling partners continuing this relationship of marriage much against their wishes, without a friendship, without a bondage, can exit as friends. So initially I was talking about friendship. even though friendship is not governed by anything, governed by any law, nobody is compelled to be a friend of the other. You will find that once there is a true friendship, which I said is something which arises from the heart, it continues till the end. So therefore, a good friendship in a marriage, in spite of this ground of irretrievable breakdown of marriage, can continue till the end if the hearts are together. If the hearts are not together and it has completely broken down and it has become a deadwood, it is high time that the law starts recognizing the fact that you should provide for an easy exit of the spouses, failing which it is going to become a big societal problem. So with these few words, I would want to ask the panelists to give their thank you.
Thank you, sir. Thank you very much. Before going to Justice Vimala, I just want to add only one thing. Saint Tiruvallur has got a beautiful Tirukural to define what is called the virtue of a family. Anbum aranam udaithayin ilvalkai panbum payanum adu. Unfortunately, the definition of anbu and aram has become so diluted or diversified. Now people started interpreting anbu in their own way and aram in their own virtues. That is the reason the present generation is able to see anbu and aram in their own perspective. So what I feel that now present scenario, marrying a person is very easy because of the amendments and the way in which the marriage is made very easy. But getting a marriage dissolved is highly tough. This is the area where the society, what is called, stands with fingers crossed. May I now request Justice Vimala to offer her deliberation. Ma'am, you are welcome.
Good morning, Brother Justice Anand Venkatesh. Good morning, Advocate Srinivasa Raghavan, and very good morning to Gopika and all the eminent persons present today for this today's session. Let me start with a joke. Though it is stated to be a joke, this joke is almost happening in the life of many couples. An angry son-in-law sent a text message like this, saying, "Your product is defective. Please take it, I am returning." The father-in-law retorted, sending a text message again saying, "Warranty period expired, therefore I can't take it back." Human emotions, human expectations, human values, there is no respect for anything. The relationship, people are not behaving like human beings and they are treated like chattels or object, and that is why and that is how problems are coming in the marital life. I must thank host, especially Mr. Srinivasa Raghavan, for this wonderful judgment written by PDJ Sivagangai Judge Nazir Ahmad, where he has exhibited the mental attitude of the couples that makes the married life very difficult. We all know that frog is amphibian. It can live both in the water as well as on the earth. After marriage, if one partner wants to cling only to the earth and the other partner wants only to cling to the water, and both of them do not want to move either side, what will happen? What is going to happen? This is the crux of the issue that we have to elaborate today. If they are not going to change the attitude, if they are not going to change the ego, and if they are not going to change the approach, what is going to happen for their marital life? Today's generation, those who are living in technological age, they are thinking twice as to the question whether they should get married at all. Not that they are going to become saint or hermit. They want to have the enjoyment of a marital life, but in a different form. Brother Justice Venkatesh was referring to the case of friendships. I was just reminded of the friendship between Engels and Karl Marx. But for Engels, Karl Marx's life would have been very miserable, and it is doubtful whether we could have got this beautiful book, Mooladhanam. He was taking care of the entire life. Even after the death of Karl Marx, property of Engels was divided and it was given to sons of Karl Marx. That is how the friendship was. Gone are the days we can expect such friendship, and with the gone are the days where such friendship we can expect in the marital life also. Now coming back to this, grounds for marriage. The brother was also very pertinent in pointing out whether irretrievable breakdown of marriage should be part of our grounds for marriage. If we have to understand whether that should come as a ground, we should first understand what is a family and what is the family court meant for, and how the proceedings are in the family court, and whether we are able to get speedy justice. It is not that we use technology, but we live technology. When we say that we live technology, the meaning is that technology is dictating our lifestyle, and because of the technological use, people want everything instant. Like instant coffee, people also expect instant divorce. There is a saying in a marriage hall, whether there should be a police station, or in each and every police station there should be a marriage hall. Even before the marriage commences, the dispute commences. That is the world in which we are now living. Then we come to the concept of marriage. A happy family is but an earlier heaven. Family might be defined as a group of people who are related to each other. It is more than that. It is a meaningful connection and experience. It is an incredible and unbreakable bond created by mothers, fathers, sisters, and brothers. It's a comfort in a world of uncertainty. It is a shoulder to lean on. It is a source of inspiration. It is love and support. It is that warm and fuzzy feeling. It is wonderful and it is necessary. I am putting a lot of slides on family because we have to consider when family is doing so much, whether we should leave. And if the family is not doing, if the family is not giving you a shoulder to lean, and it is not giving you a world of comfort, and it is not extending your love and support, whether that kind of family life should also be permitted to continue. Only for that purpose, I am just putting these slides. These are all the considerations which one should consider whether we should have that family life or not to have that family life. Call it a clan, call it a network, call it a tribe, call it a family, whatever you call it, whoever you are, you need one. That is how it was felt earlier. The family system is one of the nature's masterpieces. These are all the definitions given by our briny people. I'm just only sharing. Families are the campus that guide us. They are the inspiration to reach great heights, our comfort when we occasionally falter. Family is not an important thing. It is everything. The only rock I know that stays, the only institution I know that works is the family. In the family life, love is the oil that eases friction, the cement that finds closer together, and the music that brings harmony. The Family Court Act 1984, it is brought out only to not to have the humiliations that are very much available in the adversarial system. You'll be wondering who was instrumental in bringing that Family Court Act. As you all know, Family Court Act has special provisions and that are very special to the family court alone. The family court is empowered to have and the power to devise its own procedure for the purpose of settlement. Any piece of document is admissible, irrespective of the Evidence Act. Any kind of document is admissible. These kind of special provisions, special strategy for settlement, either negotiation or conciliation or there are too many strategies available for settlement of dispute. Why these kind of special provisions? These kind of special provisions are to avoid harassment, humiliation, mudslinging, to save time, to save nerve breaking, and there is a regard for feelings and emotions for the parties to be vented out during that negotiation. If we say that we are the civilized people, we must have at least able to get a satisfactory solution from that institution with the minimum bitterness and the maximum respect. But we enter into the family court, what we see is there is a fight, not a fight which could be imagined. Fight for sentence to sentence, word to word, syllable to syllable dispute there. Once we enter into the family court, everybody start feeling that they have entered into an institution where they ought not to have entered into. That is the kind of feeling they have. Number of years, decades, 10 years, 20 years, 30 years. At what stage? At a productive age, man marries, say at the age of 25, they have to plan the future, plan the children, then the children's study, up to they match their retirement along with the marriage of their child. To that extent, they have to plan in advance. When they have to plan their career and plan their life, if the family dispute comes in, there's a total collapse of the entire life. Then they start thinking whether we should have this kind of marriage, get trapped, and whether we should go to family court to waste all our lifetime to not to have sleep at night, and why should we do that? Let us have friendship. Not the kind of friendship my brother was referring to, permanent friendship at no cost and no expectations, not that. The law now recognizes, the Domestic Violence Act has now recognized living in relationship. See how dangerous. Even after 30 years of marriage, people have the courage to come and say that this lady I never knew. She is not my wife. They are not the children. Then DNA test. Then there is a seminar. What is the value of the DNA test? That is the world in which we are living. Then if there is living in relationship that is recognized and there is no guarantee for a stability of a family life, then where are we moving towards? Once Bill Clinton visited India, reporters were asking, what is fascinating for him? Is it the Taj Mahal or is it any other 7 other wonders? They were one after the other, they were referring to special to India. Finally, he said, what is fascinating me is the family, because the family which I see in India is like a temple. That is how it was admired once. Now that if once people enter into the family court, nobody will believe that family is temple in India anymore. Life does not mean breathing in oxygen and breathe out carbon dioxide. If it is happy life, as pointed out my brother under Article 21, if it is a happy life, whether we can permit parties to lose their happy life by fighting the litigation alone in the family court, especially when the family court setup itself gives lot of scope and provisions for easy settlement, yearly settlement of the dispute. Why the family court, despite the procedure available, is not able to settle those cases is the nature of provisions itself. When we look at the grounds for divorce, we will be able to see one of the accusing party must fit the other party into the pigeonholes where the grounds are very, very limited. Either cruelty, adultery, bigamy. There are limited grounds. Only in order to bring the case within those points, people have to tell out false stories. And if those stories are told by one of the party, the other party will be tempted to state 2 more stories to accuse the other party. Only this way, if fault is the ground for divorce, the parties are tempted to bring in false allegations, which they will not be able to prove the court of law at all. This irretrievable breakdown of marriage, where the marriage is totally unworkable or emotionally dead or beyond salvage, or it has broken down irretrievably, when there is only a bitter life, no betterment in life and betterment in relationship, then it is necessary that we have to consider the ground of irretrievable breakdown of marriage. Already 2 law commissions report are trying. 2 times the bill has been introduced and passed by Rajya Sabha and not brought before the Lok Sabha, before which the Lok Sabha got dissolved, and this is the state of affairs. Even the divorce by mutual consent was brought out only at a later point of time. One of the objections that was raised at that point of time was, what are the yardstick to decide irretrievable breakdown of marriage, and therefore it is very difficult. It is not so difficult, it is very, very easy. Living together is for the purpose of sharing and caring. And living together is not possible, and when they are living apart, it is negation of sharing. Then the essence of marriage is not there. We can certainly term it as a breakdown. And if it is breaking down for a long number of years, we can certainly say it is irretrievable breakdown of marriage. And if the children, without considering children, I do not know the how to proceed further. One of the objections raised during that time was how the objection was like this: the children's interest would be affected if the marriage is broken down. There are two more questions to it. If it is a case of unhappy marriage, in the unhappy marriage where the couples are frequently quarreling, only the children who are in this house become the juvenile delinquent, not the useful citizens. They watch only the violent scenes in the family, and they learn by imbibing it. They learn how to retort, and they know how to fight. Only that kind of learning happens to the child, and not that the child is growing in an atmosphere of peace, love, and joy where the family is expected to render. Therefore, in the name of children, it is not possible, it is not feasible to say that in the interest of the child, such kind of marriages are to be preserved. Mere introduction of the provision does not mean that the court is going to grant at any time the provision is quoted. Even if the provision, when the provision is made available as a ground, then the court will have the option of considering whether really it has irretrievably broken down, at whose fault, at whose mistake, at whose conduct, and whose responsibility it is that, and only then the court is going to grant it. Even before granting, the court is not powerless. The court can impose appropriate terms and conditions. If there are children, the children's education, the children's marriage, the children's upbringing, and the children's development, everything, the defaulting party should be made responsible. Subject to that condition, if the marriage is permitted to be broken, then it will take care of all these things. The Delhi High Court in one of the cases said, it is unreasonable and inhuman to compel the parties to live together when they are not able to. This language I really enjoyed, but it is inhuman to compel the parties when they are not willing to. The minimum bitterness and the maximum fairness must be the solution to the parties who are approaching the family court. Yes, the youngsters are coming before the court. Youngsters are also saying that we will throw away money, and they are prepared to get divorce. It is not a question of throwing away money. It is a question of throwing away human being as useless, that the youngsters should understand that. The court, while granting divorce, which should not be complex, which should not be time consuming, which should not bring bitterness, must have easy provisions for grant of divorce, and it should be in accordance with the changing needs of the society and the changing times. Times are changing. People are not able to wait. People are not prepared to wait. People are not able to adjust. If they are not able to adjust from the beginning, from the time of inception, we have to inculcate values to them. It is not sufficient to say no after they have attained a particular stage of growth. And therefore, I think irretrievable breakdown of marriage must be a ground available at the earliest point of time. It should be made available in the statute. The Supreme Court in too many cases have granted divorce invoking Article 142. Many other High Court, I have seen the judgments of at least 4 to 5 High Courts where on the basis of irretrievable breakdown of marriage, divorce has been granted. But what about the district courts and the family courts? And they also feel that they are not able to do complete justice. There is no purpose in keeping these kind of marriages intact but they feel powerless. In the basic courts, where they are able to see the parties and they are not seeing the files, they are able to see the life of the parties before them, and they should not feel helpless. Wherever there is no law providing for that, justice, equity, and good conscience must be the ground available for them to consider the claim for separation or divorce. And in several cases, the Honorable Supreme Court has said the court has got the power to take note of the subsequent events and to mold the relief without even an amendment. The conduct of the parties before the court, if the judge is able to visualize, if the judge is able to understand, and the judge is able to interpret, see the case for disposal takes 5 years to 6 years, there is no resumption of cohabitation. Say supposing there is an order for maintenance that is not complied, not paid, order for restitution of conjugal rights not complied with, then the necessary intention is that the parties do not want to live together at any cost. Then it is a case for grant of divorce without doing much damage to the emotions of both the parties, and therefore law should move in accordance with changing time. This is my humble view to the elite audience to consider, discuss, and ponder over. Thank you very much.
Thank you, ma'am. Thank you for your illustrious ideas and the sharing of the knowledge. Now the question remains that what about the youngsters? What the present day young generation think of the institution of marriage and how they are going to pursue the change of the institution or the way in which marriage is being viewed and the way in which they want the marriage to be kept intact or dissolved so easily. So let me invite Ms.Gopika Nambiar, young lawyer who has just finished law from School of Excellence Chennai and is currently attached to Ms. Sai and Bharat, one of the best motors of the country. Ms. Gopika, you can now start your session. Yeah.
First of all, thanks to you for letting me participate in this webinar, for giving me this opportunity. And good morning to everyone. I'll first of all place on record a caveat that I come with less than 2 years of experience, and therefore my knowledge and experience is limited. And secondly, speaking in the end after two eminent speakers who have so much of knowledge on the subject is a Herculean task by itself. So I'll just try to do my best. So when I saw this topic, what first came into my mind was the principle of statutory anachronism. Now, even Lordships also touched upon that aspect. Now, when is the principle of statutory anachronism come into being? Is when law does not keep pace with society. Anachronism is when something gets outdated, when the statute gets outdated. So the society has progressed, the interest and the expectations of the individuals, their way of thinking has progressed, but the law remains the same. So that is when we have this problem of statutory anachronism. Now, even recently, we have seen many judgments of the Honorable Supreme Court where they have tried to dispel statutory anachronism. Example would be when Section 377 was struck down by the Honorable Supreme Court. Gender was seen as not a binary concept anymore. The fact that gender was only binary was seen as anachronistic, and therefore, that concept gave way. Sedition, in fact, is largely seen as an idea that is increasingly anachronistic and not in line with freedom of speech. And there is an increasing call to remove sedition from the statute books. So this is where statutory anachronism is a very important principle. Now, if we look at the Hindu Marriage Act, what we have studied, in law school and even before that, our parents always instill us in, the fundamental aspect that Hindu marriage is a sacrament. The institution itself is a sacred institution. And it is slightly different, of course, from other religions. For example, in Muslim law, marriage is a civil contract. Now, if we look at the grounds of divorce, we see that they are extremely specific, limited grounds of divorce that are available under the Hindu Marriage Act. Now, the reason that the legislature proceeded to put in these specific limited grounds of divorce is the fact that the institution of marriage is a sacrament and it is something that should not be dissolved easily. Now, when a divorce petition is presented in court, all of us know that there is an inherently high level of scrutiny. There is always an effort done to save the marriage rather than dissolve it. Now, of course, the ambits of the grounds of divorce have been, broadened over the period of time. For example, cruelty is something that has quite a broad ambit now by the High Courts and Supreme Court. But inherently, there is a standard of scrutiny. Now, even in the judgment which Lordships referred to in Munish Kakkar versus Nidhi Kakkar, citation is 2019 SEC Online, Supreme Court 1636, which is the judgment wherein Supreme Court invoked their power under Article 142 to declare a marriage as irretrievably broken down, even though the respondent was ready to continue the relationship. Now, in that judgment, when for the High Court judge noticed the same facts, and if you read the facts, it is quite clear to all of us that the marriage itself was itself an empty legal shell. So when the High Court was looking at the matter, they said that, yes, the marriage seems to be an empty legal shell, and there are very grave imputations that were raised by both parties. But even then, this is not enough to break the formidable wall of marriage. These are the words which the High Court used, which means that the general judicial thinking based on the legislature and based on the concept by which the statute itself was enacted is that the wall of marriage is generally an impenetrable foundation an impenetrable foundation which can be broken down only if there are those specific limited grounds that are mentioned in the statute. Now, whether these grounds have become anachronistic or whether they have become outdated, and if there is a necessity to introduce this irretrievable breakdown concept is something which we have to understand by revisiting the concept of marriage. I may be repeating a few things which Justice Anand Venkatesh said, but it's quite necessary for us to properly understand the sociological aspects so as to appreciate the need for bringing in the irretrievable concept. Now, as per Hindu literature, Hindu marriage is something which is irrevocable, indissoluble, like Lordship said. Therefore, the concept of divorce itself is alien to a Hindu marriage. Now, Mr. K.M. Kapadia, who is the founder of the Indian Sociological Institute and who has written a lot of works on marriage and divorce, what he has explained Hindu marriage very aptly. He has said that marriage under the Hindu society is a social duty that an individual does for his family, for his society, and for his community, with very, very little scope for individual interest, with very little or no scope for individual interest. Therefore, individual interest and his aspirations are not given prominence in the traditional Hindu concept of marriage. So Hindu marriage was about fulfilling your obligations towards the society, sexual gratification, as well as producing progeny for the continuation of the lineage. Now, this is in stark contrast to the traditional Western philosophy of what marriage meant. Social anthropologists in the West have very clearly said that in a marriage in the West, what is important when two individuals come together is their needs, their aspirations, and their requirements. It is not about fulfilling any obligations towards the society or the community. Now, this is, of course, not what we followed in the traditional Hindu concept. And principle of familism was what was followed. Even in the process of arranging marriages, there was, not much of democracy, as I call it, because it was the families that met, and the prospective groom or the bride never met each other. It was the families that arranged the marital union. And also, the concept of marriage, in fact, at that time was restricted to communities in the sense that intercaste or interreligious marriages were not recognized. Also, it meant that when there was friction in the marriage, these families or these communities acted as mediators and counselors, and there was not many cases of divorce. And the other factor, of course, is also that child marriage was prevalent. There was an increasing age gap between between the man and the woman. So there was an inherent, I'd say, inherent feeling of being able to look up to them, and therefore inherently the divorce rates were down. Now, all of this changed in the third quarter of the 20th century. There was a series of surveys that were taken by sociological institutions. Now, in the first survey, which was taken on women, it was seen that women wanted to marry only at the age of 20 to 24. This is in the year 1959, and not before that. Then a series of surveys taken in the 1960s showed that the higher a person got educated, the later they wanted to marry. Then there was another survey which was taken, which showed that 64% individuals wanted a very clear say in the decision to get married, along with their family. They wanted it to be a democratic process. And presently, of course, there is obviously a opinion among youngsters that selecting the spouse should be solely their discretion, and not the family should not even get into it. But what I want to reinforce is the fact that marriage, even under the Hindu concept, has moved from being community centric, or from being a social obligation that one does to the family, to the community, and to the society. It has moved from that aspect to something which is based on individual interests, which is based on individual aspirations and individual growth of the people. Now, there are many, of course, reasons for that. In fact, the Delhi High Court in one of its judgments even say that female emancipation has been directly proportional to the rate of divorce. Now, this is of course, something that can be debated on. But the concluding aspect of the fact is that community interest or community obligation has given way, and a westernized concept or westernized philosophy of focusing on individual interest has taken its place. Now, this young generation, when they look at the Hindu Marriage Act, it is not necessary that the ground specified, the limited ground specified in the Hindu Marriage Act is something that they feel is necessary for a marriage to be ended. If I were to give an example, incompatibility is largely seen as a ground which is cited by two individuals to break away from marriage. Now, incompatibility is not something that will fit in any of the grounds enshrined in Section 13. So what happens, like Lordships also said, is that since the grounds of divorce which is enshrined in the Hindu Marriage Act is based on the fault theory, the fact that if I were to get a divorce from someone, I have to necessarily establish that the other person is at fault. Now, this ethos has come from the traditional concept that it is a sacramental institution, has to be preserved, is indissoluble, and therefore only if there is a grave fault on the part of one party can the marriage be dissolved. So this is why, just like Lordship said, that divorce petitions are filed with sometimes absolutely improbable allegations. I happened to once see a divorce petition in which the wife had written that the husband had an affair with his own mother and sister. So these improbable and absolutely scurrilous allegations come in because you have to necessarily prove that the other party is at fault so as to get the divorce. Now, in contrast to that, the irretrievable breakdown theory enshrines the fact that if you are not able to mend the marriage, you better end the marriage. The Law Commission of England, in fact, very beautifully says that when marriage becomes an empty legal shell, it is the duty of the court to end it with maximum fairness, minimum bitterness, and humiliation. So that is what the breakdown theory essentially embodies. And also, as Lordship said, 217th report of Indian Law Commission said that irretrievable breakdown theory should be brought in the concept of divorce. Now, therefore, I do find that there is statutory anachronism prevailing in the grounds of divorce mentioned in the Hindu Marriage Act. Now, what is the result of this statutory anachronism is the fact of the rise in live-in relationships. Now, what live-in relationships are is very finely pointed out by the Delhi High Court, wherein they said that a live-in relationship is a walk-in and a walk-out relationship with no strings attached. It is akin to unilaterally revoking a contract wherein you can walk out at any point of time. Though the Supreme Court has in some ways regulated live-in through certain judgments, but essentially the concept is that you can walk in and walk out whenever you want. So my point is that this need for autonomy to end relationships has resulted in many people in the younger generation favoring live-in as opposed to that of marriage. Now, when people talk about wanting to strengthen the institution of marriage, they say that the grounds of divorce should be made more narrower, should be made more stricter. Now, I feel that will not work to to the benefit of marriage, and it might even work to the detriment, because I feel that as you make the grounds of marriage more narrow and more stricter, the present generation, which focuses on marriage as being a personification of their individual interest and not any kind of obligation that they do towards the society or the community, they will prefer these alternate kinds of relationships like live-in relationships rather than stick to a marriage wherein not only the procedure for ending it is very long and tedious, but also the fact that you have to establish that there is a fault on the other party. So therefore, I absolutely circumscribe with what Lordship said to the fact that there irretrievable breakdown must be introduced. And also, I feel that the ground itself should be made more broad-based in the Hindu Marriage Act. Now, even if we see the Christian Marriage Act, the Christian Law of Divorce, which is the Indian Divorce Act, it also is quite anachronistic, because a husband is allowed to get divorced only when he proves adultery, and a wife is allowed to get divorced when the husband converts into another religion, or if there is adultery combined with certain other aspects. Now, if we yes, the only difference, of course, that the Indian Divorce Act provides is that it gives some kind of legitimacy to prenuptial contracts relating to child custody, or relating to property division, which the husband and the wife might have entered into at the time of marriage. Now, if we look at the Muslim law of divorce, now generally the perception is that Muslim law of divorce is considered to be questionable in terms of rights and of women and certain other aspects. However, if I may quote Justice V.R. Krishnaiyer, who in one of his judgments before the Kerala High Court, the case law is Yusuf versus Swarnamma, AIR 1971, KER 261, has said that a deeper study of the Muslim law of divorce reveals a surprisingly rational, humane, and modern law of divorce. So, in the traditional Muslim law as it existed, the husband, by pronouncing a talaq, can talaq within, of course, there are certain time periods, certain rules regarding that. But once he pronounces the talaq 3 times, he gets, his matrimonial obligation towards his wife has ended. Now, the same right is also available in Muslim law to a wife. What she pronounces is called as a kula, or a talaq-i-tafund. And its attributes are exactly the same as that of a talaq. Therefore, the man and the woman in Muslim law are given individually the rights to walk out of an unhappy marriage without having to justify the grounds based on which they exercise their discretion. Now, even after the enactment of the Dissolution of Muslim Marriage Act 1939, if you see, which is of course a legislation whereby if the Muslim lady wants to go to court to get a divorce, she can go. And even in the grounds enshrined in that act, there is a residuary grounds which says that divorce can be granted on any other ground recognized as valid for dissolution in Muslim law. Therefore, since Muslim law recognizes the unilateral ending of marriage without having to justify on the grounds, there is a school of thought led by Mr. Tahir Mahmood, who's of course a great scholar in personal law, which say that this residuary ground can be invoked, wherein a woman can get divorced without having to justify before the court as to what is the ground. So this kind of freedom is given in Muslim law, and that Muslim law therefore embodies the concept of irretrievable breakdown of marriage. Therefore, finally, if I were to just conclude on three, based on three aspects. One, yes, irretrievable breakdown theory should definitely have a place in the matrimonial laws on divorce. Secondly, I feel that what is most important, which can be done to facilitate reconciliation, is having a pre-litigation mediation. So once after parties, file the divorce petition, after that we send them to mediation. I feel that once you read the petition and all the, of course it is based on the fault theory, and therefore there are lots of faults which are enshrined, which have not even taken place. Once the other party reads that, I do not think they are in the correct mindset to go in for a settlement. Therefore, pre-litigation mediation should be made compulsory. Lawyers must not be involved in that process. And, there must be a step taken at that time so that the parties themselves understand their interests, and they can look at the future of marriage prior to instituting a litigation in court. Thirdly, this is of course something which Lordship also referred to. If in the future, if we are moving towards a uniform civil code, there is one more line of thought that we can think on, is whether the right to break away from a marriage should be based on grounds enshrined in law, or whether it can be completely left to individual autonomy. Lordship also alluded to it about Article 21, but of course there are many problems in that, child rights and things like that. Therefore, I'm not endorsing nor declining that idea, but it is something that we can ponder about if in future we go to a uniform civil code. That's all. Thank you so much for giving me this opportunity. Thank you.
Thank you, Gopika, for your beautiful thought process, and the clarity of thought and the clarity of expression is very appreciable. And as you have rightly represented the voice of the youth, I think the elders will take note of it in the right spirit. And I want to add only one thing. From what you said, I understand that the matrimonial dispute should no longer be a domain of adversarial jurisdiction, right? It should not form part of adversarial jurisprudence. It should be so liberal so that the parties are not in a position to live together peacefully, means they should be allowed to depart for easily, peacefully. At the same time, let there be no imbalance in economic terms so that the wife is compensated sufficiently and the children are protected in the way in which they want to be protected. So thank you for your kind deliberation. Thanks a lot. And now may I request Justice Anand Venkatesh to give his thoughts about what Ms. Vimala and Ms. Gopika has deliberated.
Yeah, so in fact, out of the three, Justice Vimala had a really great experience on this, and she had dealt with a lot of cases on this. So therefore, Justice Vimala is completely aware about the ground realities that are prevailing. And as she rightly said, that many cases in the family courts, the atmosphere in which the so-called conciliation is all taking place, it's like a war field. We find parties coming to blows. Unfortunately, advocates to an extent are also contributing for the confusion that prevails there. The advocates must always have one thing in their mind when it comes to the matrimonial proceedings, or when it comes to the motor accident proceedings. These are proceedings where they are not dealing with a property. They are dealing with the hearts of two individuals. And at the end of the day, when you are dealing with a situation like that, you should forget about your own personal aggrandizement in that. You should forget about the law on that. At the end of the day, you should see whether they can really help the parties to either come together, or if it's not working, to help them to have a peaceful exit. That's what is very important. It is very, very, very important that already there is a problem between two persons, and the advocates are not supposed to contribute more and make it worse. That is not the role of an advocate at all. So as rightly said by Justice Vimala, The family court was brought in only for that purpose. If it had really served that purpose, there is no problem. But one family court has become 7 family courts today. It's like, somebody was joking me the other day saying that it looks like people get married and within a year they get into one of those family courts. See, it's easy to keep joking this way, but we are looking at a situation where this marriage as an institution was considered to be one of the most important ingredients to keep the unit of the society together. So if we don't properly attend to this problem, it is getting broken, and when it is getting broken, the situation is created where it is getting more and more murkier and washing dirty linen in the public, and with the type of social medias, etc., which we have, it is getting worse every day. So therefore, it's very important to attend to it. So when it came to Gopika, she wonderfully presented her point of view. And I did not want to touch upon Muslim law for a moment, because as she rightly says, in at least 2-3 judgments I have seen, the judges saying that that independence of getting out of a marital tie was available. Probably, I think, because of the very nature of marriage as contemplated under the Muslim law, where it is more a civil contract between parties. Here in Hindu and Christian law, it is always considered to be a sacrament. The words are all fine, but nobody today is prepared to accept that marriages are made in heaven. According to everyone today, marriage is an individual choice of 2 persons who are willing to get together and lead a life. That is how it is being seen today. So therefore, it is important that we meet the present day requirement. There is no use in complaining, saying that the marriage institution has kept this society this way, therefore we'll have to. All that is right. But there has to be a workable solution that should be available today. We should not make it even more tougher. As Gopika rightly said, that they are feared to get into the marital tie because it's very difficult to get out of it. As I initially said, a golden cage, you lock yourself, throw away the key. Right through, you will be inside the golden cage. Cage is golden, but there is no use in being in a cage like that. So as she rightly said, the parties are very, very hesitant. I have spoken with a lot of youngsters on this. They are very, very hesitant to get into this tie, because they know that once they get into a tie, they are getting into that gold cage where they have to throw away the key. So it's very important to meet this situation, and I am sure that it is changing. You see, there is no use in saying that it's all changing, it's all getting worse, etc. You can do nothing about it. Changes are a part of life. So every time there is a huge change that happens, you will have to somehow keep in line with that. There is no use in making 2 people out of force to undergo a relationship like that. At the end of the day, according to me, it is not necessary to maintain this institution of marriage with 2 broken hearts. That's not necessary. And we have moved out of the thought that marriage is something, it's a duty towards society, duty towards family. All that is gone. Today there is no joint family, there is no nothing. Today everything is a unitary family. So therefore, let us accept facts as they are, howsoever uncomfortable it is. So therefore, it's important that we keep discussing on things. And in fact, I was really benefited hearing Justice Gopika on this issue. To want get in, and if they have any queries, they can put.
Question posed by Justice Vaidyanathan is this: husband and wife have 2 worst qualities: intolerance and ego. Don't you think if they burn it to ashes, there will be no bondage, not bandage? Love and affection, mutual trust and confidence is maintained. Is not the Domestic Violence Act boon to some lawyers and bane to family members, including litigants? Should not DV Act be made neutral by making necessary amendments to the said Act? And firstly, criminal court jurisdiction should be removed from the Act. Will live-in relationship is better than marriage to avoid matrimonial litigation. And in present day, the marriage relationship itself appears to be a contract rather than sacrament. This is the question he wants to post to all the three panelists.
Basically, when I started the discussion, I said that the reason why things are getting aggravated either on the criminal side or on the domestic violence side is because the parties have come to a stage where it is becoming unworkable. Since it is becoming unworkable, we do not have a mechanism where we attempt to bring them together and attempt to make them understand their responsibility. So what happens is that we are further aggravating the problem by two ways. One, by keeping cases pending in courts without a resolution. Number two, advocates also aggravating the situation by trying to lend their own imagination into a lot of problems. So therefore, what is happening is that once that starts, what is happening, what is the consequence? There is a sort of, the wife wants to take a revenge over what is happening. So what do you see in domestic violence petition? You find the father-in-law, sister-in-law, brother-in-law, this law, that law. You will find 20 respondents. The only person who would not have been made as a respondent is the advocate who is representing. Fortunately, if he had gone anywhere near there, he would have been made as a... Why is that happening? It is happening not for a resolution at all. Please understand, most of the domestic violence petition, I have sat in 482 jurisdiction for more than a year. And I was privy to what was actually happening. Most of the domestic violence petition was a sort of a revenge that is taken by the wife against the family. And in many cases, she may be justified in that anger. I'm not talking about the anger, but look at the consequence. Consequence is that you have made everybody in this earth as a respondent. And what is that going to result into? It is going to result into a further deterioration in the very relationship itself. And who gave you that advice? I'm sorry, the advocate who is representing the wife gives that advice. He says that bring everybody there. We will see that they come to some sort of a... So that is one side. The second side is your criminal side. In the criminal side, the dowry death and the cruelty, etc. was brought for some other purpose. Today, what is happening? What is happening is that if the parties are not going to concede for certain things, for the purpose of either coming together or to dissolve the marriage, then it is used more as a tool to force a party to come into the... See, therefore, what is happening is that is criminal side is being used for the purpose of arm twisting and making things happening this. In one of the recent movies which I was watching, I think it's a movie called as Tapad. There you will find a scene like that. The person initially will say that if we are not going to properly end it up, you will find that there will be a criminal complaint before the police station where it's possible that you, your father and mother will get arrested. It will not happen initially. But when things were not moving properly, ultimately what that advocate said will happen. What will happen is that they'll say, okay, we'll give a complaint to the police station. Then why is it given? It is given not actually to end up it. It is given only to arm twist and make the other party accept to certain demands made. So today you have a Domestic Violence Act, you have a 498A, you have a 125, you have a lot of things. But what is happening is that since we are not focusing as to how this relationship has to be now seen, and since we are not really helping them, we are aggravating the situation, these misuse of powers, particularly with the help of the advocates, is going to be on the increase. So today we are talking about an ego. A man always had an ego right through in history. Today a woman is questioning him. A woman is now educated. A woman is today economically independent. A woman wants to have a career of her own. How many men are with wholeheartedness saying that, yes, I am your friend. I will allow you to go forward or go up in your career. I'll help you in going up in your profession, etc. How many are there? What ego are we talking about? Every time when it comes to ego, the easiest thing that a man does is the women are having too much of ego, therefore she is not good. Please do not point out like that. What is important is that when it comes to ego, man and woman, both of them are human beings. So both of them are bound to have their own egos. Ultimately, how is that an advocate and the court is helping in handling the persons with egos to come together or to have a peaceful exit from their life? We are not helping them. Advocates are not helping. Courts are not helping. Law is not helping. So what is happening? What is happening is that once the parties come before the court with a problem, for 10 years we drag them, we finish off their whole life itself. Therefore, it requires a real rethink, is what I feel.
Thank you, sir. This Vimala ma'am, the same question to you. What is your answer for this? Is Vaidya's question.
I think the question itself has an inherent answer. It appears to be a note or a commentary and not an exclusive question. That is what I look at. But however, whether the criminal law should be part of this marital problems, that requires a very serious consideration. At times when the entire family, namely the parents of the in-laws, are brought before the court, once they have been worshipped as the leaders of the family, and when they come before the criminal court, they are looked upon as accused. All throughout the life, when they are worshipped, at one point of time, they are looked at in a very humiliating way by the entire society. They are broken into pieces. Then the bride used to think whether we should go into the system of marriage at all. That is one of the reasons the criminal courts, the way in which the criminal courts are dealing with them. I would like to share with you a case. It's a case of a young lady aged 21. She was married. There was no happiness in the family. She come to the parents and tell them that she is not happy. The parents did not ask her what made her to be unhappy, who made her unhappy, why is that she is not able to live in the family. No inquiries at all. Simply they say, once you are married, you belong to that family, you don't come here, you go and live, whatever may be your problem. Nobody had the inclination to ascertain what is her problem. In the marital home, they took advantage of that and they did not really address her problem. Finally, she wrote a suicide note like this. For the past 5 years, I have been patiently waiting. There is no conjugal relationship between me and the husband. When the husband is at fault, in order to suppress that, he is harassing me more, saying that I am not beautiful. Maybe a justification to say why he is not able to consummate the marriage. See the kind of sufferings. Finally, after putting the suicide note, she died. Finally, the abatement to commit suicide case comes before the court. Who are the parties? The husband and the in-laws. In-laws naturally say they do not have any personal knowledge regarding their personal relationship. That is what they say. See the way in which mechanically the families are functioning. When a girl is not having consummation of marriage for the past 5 years in a family, nobody knows but for her suicide note. When such kind of cases are coming, when the bride burning cases are increasing, suicide cases are increasing, the solution would be premarital counseling. We say that marriages are made in heaven, not that. In villages, marriages are made by parrots. They just go and simply stand before and the parrot will take some note and he will read it, then they will decide that they will marry. In the town, the manipulators of horoscope are deciding the marriage. Gone are the times when people are able to adjust with everything. Now that the horizons of the attitude, aptitude, knowledge, compatibility, everything is tremendously increasing. What are they? What are these human beings? What is their psychology? What is their way of brought up? How do they react? How to maintain interpersonal relationship? How to maintain an intricate relationship? There are too many things to be taught for them. Too many things to be compared, too many parameters to be considered before arranging for the marriage. even if anything it turns out to be incorrect or something incompatible, then it is for them to have a family counseling, welfare experts, then the counselor, psychiatrist. There are too many persons available for help. Those help they must seek. When they do not know what is the problem at all, how are they going to solve it? There is no solution by saying that people will be allowed to commit suicide and then we will try them and put somebody behind the bars. There is no use for the society. And that if there is a good evolution of the another generation, necessarily the family should have some values. Family should not treat the other partner as a commodity. They should have some kind of values for emotions. In the premarital counseling, some kind of education regarding what is a family life, what is the relationship, what is the sexual life, everything. We are afraid of talking about sex. Women do not open up the problem at all. Nobody is able to give solutions for that. We must start the couple as to what if there is a problem, how to solve it. Only then the cases can be some extent it can be prevented from going to criminal court. So long as bride burning is there, so long as dowry death is there, we can't take away the jurisdiction of the criminal court. Yes, thank you, sir.
Thank you, madam. Gopika, what's your take on this Vaidyanathan's query?
So I think just picking up from where Lordships left, after Corona broke out, the newspapers reported that both abroad as well as in India, there was an increasing calls that were received by the domestic violence helpline number. So a lot of women were ill-treated when, they were in lockdown with their husbands. And therefore, like Lordship said, there is definitely an increasing need for premarital counseling and, looking at what relationship between a husband and wife should be. And that leads me to Lordship's third limb of the question, which was about whether live-in relationships are now the order of the day and whether, there is any necessity for marriage itself. So I feel that I do not think that the younger generation is opposed to marriage because live-in is not something which their families would agree to. And whatever we say, we even though we've moved towards a Western society, we are still inherently very attached to our family. We live with our families, and therefore families' consent is very important. So what would be more preferable would be an individual interest-based consideration of marriage, which can, that can be started by, introducing irretrievable breakdown as a ground to show that a marriage is not like Lordship said, is not when you're locked up in a golden cage. It is also something it is also a concept which is recognized that you can of course have a failed marriage without the fault of another party, without having to necessarily say that the other party is at fault. So I feel if that concept of marriage itself has itself undergoes certain changes, I don't think there is any necessity for anyone to go in for a live-in, because at the end of the day, financial, emotional security and security for the future of the children are something which everybody wants. And marriage is something, it is a very good institution, but with some modifications based to, to suit the present generation. That is what I feel.
Gopika, I have one question to you.
Yes, sir.
Do you think incompatibility is part and parcel of the ground of irretrievable broken down marriage? Are they equal to, are they similar to each other? Or are they different to each other?
I think it can be a part of it, sir. Though irretrievable essentially means that it can never be, it can never be patched up. But you know that what elders would tell us about incompatibility is that you have to compromise and you have to adjust with each other. But I feel if you take in the attitude of the present generation, to adjust and to compromise with each other is seen to be a very a Herculean task, which sometimes is practically not possible. So in such cases, I feel even incompatibility can be brought in.
So you should be made a separate ground of divorce if the parties come to know that they are not compatible to each other.
But there would be some difficulty in making it a separate ground of divorce because of the fact that what is the contour of incompatibility, what is incompatibility between you and me would not be, with other people. So that would be difficult, I think. But it should be based on the facts of the case. Bring it under irretrievable. If the incompatibility is so vast, then grant them divorce.
It is as evasive as mental cruelties.
It is. Unfortunately, it is.
Thank you, Gopika. Mr. Kripakaran.
Is it only about the grounds that is going to be needs a change, or even the process which a person has to
So
undergo.
your question is whether the proposed amendment or change is only towards the grounds or the process also?
Towards the process.
Sir, I think a process that my friend is referring to is a process in case of mutual consent. Mutual consent has, maybe if the court comes to the conclusion that the mutual consent itself is not free, or something is fishy, or some fraud is behind this mutual consent, yes, they can send them for mediation. Not in all cases of mutual consent invariably for mediation. What is there to mediate in a case of mutual consent? Processes are fine, but it must be judiciously used depending upon the facts and circumstances, not at all times mediation and not at all circumstances. Process is available and it is for the court to use it judiciously. What is needed is only the amendment in the grounds, in my opinion.
Dr. Sangeeta Sriram.
Talking about advocates aggravating the situation, about the need for pre-litigation mediation, etc., etc. So should we also be considering extrajudicial dissolution of marriage possibility, like an alternative settlement of dispute? Would that be a solution? Would that be the way forward? Something other than courts being involved, because that's how the family courts came into being. The family courts came up with the idea of advocates not being involved in the process much, and it not being all about the papers and the green sheets and the white copies, but about the parties coming forward and expressing their opinion. So now, should we be considering an alternative settlement of disputes for dissolution of marriages?
Without involving the courts or the advocates or any legal process, right?
Yes, some alternative. I'm not
AD, any alternative dispute resolution mechanism.
Yes, sir. Thank you.
NAVG, sir, your take.
See, basically, we have to understand one thing. A marriage has a lot of legal consequences to it, with regard to the property, with regard to the children, their rights, etc., etc. So therefore, a marriage per se is not left as it is. It has a lot of consequences to it. So since it has a lot of consequence, one, and two is that even today, this cultural makeup of mind where we have to preserve this institution of marriage is still prevalent. And according to me, it should not be watered down because there is a lot of reasoning behind it. So since that is available, that fundamental is prevailing even today, it becomes the duty of the court, of the judge, to make an attempt to see if the parties are able to come together. And it's important that there is a judicial framework for doing it, because to privatize this also is not very safe, because even with regard to commercial disputes where arbitrations are taking place, I'm not very happy with the way it is happening right in this country. So therefore, it will be too risky to really contemplate an extrajudicial sort of relief or relief that can be given to the parties at this point of time. We have not reached the stage like that. So it is important that we keep these fundamentals together, namely one, that a family, that a marriage as an institution needs to be preserved for all those advantages which it had and which had actually sustained this society together, number one. Number two, the marriage by itself has a lot of legal consequences. Therefore, it is important that a judicial setup is there for the purpose of either preserving it or dissolving it. And number three, it is highly risky to think about an extrajudicial dissolution or sort of institution which can deal with the dissolution of marriage, because we are not at that stage. Our society is not ready for all that for the present. So therefore, I would feel that it is important to fine-tune, to tweak the existing system and find out ways and means to ensure that this dissolution of marriage does not get murkier, does not become a world war-like thing before courts, and to find out a solution to see if the parties can be given an easy exit if ultimately the relationship is not going to work.
Thank you, sir. Thank you. Let me move to Mr. B. Mohan.
Yes, my question is primarily directed to Justice Anand Venkatesh. Sir has narrowed down the scope of this discussion to irretrievable breakdown of marriage. So my question is whether irretrievable breakdown of marriage, is it going to be a ground? Other is it envisaged as a ground which is going to be unilateral or to be taken by both parties for a purpose of decision? Because then the natural question will be, if it is going to be mutual, then there is already a ground for mutual consent. If it is going to be a ground which has to be taken as a unilateral ground by one of the parties, then it will automatically, will it not fall in the other grounds of cruelty or desertion and other things? So in what way is irretrievable breakdown of marriage a unique ground which needs some level of legislation?
This good question, Mr. Mohan. See, basically you are right. If both the parties understand that the marriage is not going to work for them and it is now a dead wood, then you are absolutely right in saying that you don't need to go and search for grounds. Mutual consent is already available under 13B. You are right. So when we talk about irretrievable breakdown of marriage, we are talking about the same being made as a ground by itself. But ground by itself, meaning that on the facts and circumstances of the case, one party wants to get out of the relationship and the other party wants to, for any reason, wants to sustain the relationship. And as between these two diverse stands that are taken by the parties, the court, taking into consideration the facts and circumstances of the case, finds that it is true that one party wants to go out, other party wants to remain, and the court is not able to really bring that within any of the grounds that are contemplated under the prevailing act. That is where the difficulty is. That is why I said that till this is brought in, it is possible that we can expand the horizons of this concept called as cruelty. It's always possible to start reading it within the mental cruelty also. See, that is why I said that it would have been really great if the Honorable Supreme Court, in one of the decisions, instead of invoking a 142, would have thought aloud and expanded the scope. And if it had only read this into mental cruelty, it would have become a good precedent, and it will be easy for even a family court to employ it in a given case. Today, the problem is, what is a mental cruelty is something which you cannot define at all. It's impossible to define a mental cruelty. So therefore, what is expected is a sort of an exaggerated, see, for instance, a person who is hypersensitive, who is very petulant, these are things which are not really considered to be cruelty. It may be, it will not pass the muster when it comes to gauging whether it is cruelty or not. Under such circumstances, when the parties have separated for sufficiently a long time and their emotional bonding is gone, they have no bondage at all, they are not able to see eye to eye, and nothing has happened between them. And the courts will have to be given a chance to say that all that is right, but I don't find anything to really get both of you together because it's not going to work. So I want to grant divorce. Either you have to have a ground as an independent ground called as irretrievable breaking down of marriage, where the court needs to just record its finding as to why it came to such a conclusion. That's all. If that happens, you don't need to really wash dirty linen by imagining and writing a lot of things in the petition or making allegations against each other. Or the Supreme Court, till a law is settled, or till the legislature brings in an amendment, it becomes important for the Honorable Supreme Court to, in one decision, to read something like that into mental cruelty. It will become very easier for the family courts or any other court or the High Court to really take it as a precedent and expand its horizons. That's what I'm insisting. That's what I said. So every time, instead of using a 142, probably in a case, the one case about which I was talking, this Manish versus Nidhi case, was a clear case where it is possible to read mental cruelty into that case. So to confine it as an irretrievable breakdown of marriage, which is not available today, is the difficulty. That's the difficulty.
So then the natural follow-up question will be, then the ground of irretrievable breakdown of marriage, should it be made available to the parties or to the court? Because today the Supreme Court under 142 alone is able to, because what happens is, if it is the danger of allowing this to be a ground to be raised by the parties, then it will naturally fall into one of the grounds already existing. Because one party is going to blame the other party, saying that that person, that is the one spouse, the other spouse is responsible for the irretrievable breakdown of marriage. And naturally the responding spouse will say, no, I am not responsible. So my humble view or my query is that whether such a ground should be available only for the court to decide based on the evidence that is let in, or whether it should be allowed to the parties.
See, Mr. Mohan, I'll tell you this. Let me tell, there are two ways of looking at it. One is that when is this irretrievable breakdown of marriage even becoming a ground for consideration? It becomes a ground for consideration where the parties have lived apart for a very long time and there is absolutely no bonding whatsoever between the parties at all. Let us understand that as the basic fact when we talk about the irretrievable breakdown of marriage. So what will happen is, the irretrievable breakdown of marriage, if it is provided as a ground, two things may happen. One is, a case which would have started as a case which is pigeonholed into one of the grounds that is available, over a period of time, ultimately 5 years, 7 years, 10 years have passed on, and the parties have never even attempted to get together, and there was no opportunity for the parties to get together, and ultimately the emotion is dead. It is now a deadwood. At that point of time, instead of unnecessarily getting into that pigeonhole and seeing whether the ground is made out, there must be a way out for the courts to declare that the marriage has irretrievably broken down. So it has to be available both ways. It has to be available both ways. One is where the parties have attempted for a long time, they are not able to come together, they have lived apart for a long time, and ultimately the parties decide that it has irretrievably broken down, therefore you grant me divorce on this ground, must be available. And it must also be independently available for the court to employ this ground, even though initially the dissolution of marriage was filed under some other ground. It has to be available on both ends.
Justice Vimala's view on that. Justice Vimala's view on that.
Irretrievable breakdown of marriage, when available as a separate ground, we need not necessarily impute allegations or fault on the part of the other side. I may simply say, my habit is this, it is not liked by her, and therefore there is no adjustment between us. There are too many circumstances for both parties not being able to live together. The question of imputing fault does not necessarily is ingrained in the ground for irretrievable breakdown of marriage. Therefore, it is not a question of imputing allegations against the other party. Desertion in some cases could be considered as an extension of breakdown of marriages. On a ground of desertion, I go to court, it takes another 10 years. Another 10 years, we are not living together. Then there is an end of it. The court must interpret the circumstances. Court must look into subsequent events, and court must be willing to see the pathetic condition in which they are approaching the court, not mechanically drafting the same provisions and to say no to them. We are not there to say no to everything. We should give some kind of possible relief under the given set of circumstances. Only that.
Thank you.
Ms.Gopika?
Yes, sir.
I think you had the question of Mr. Mohan. My supplementary question is this, sir.
Yes.
Whether the new ground we want to bring it to the statute must be the extension of the existing ground, or it must be a unique new ground totally altogether. As Vimala Justice has rightly put it down, sometimes the new ground, proposed ground, may be an extension of the ground of desertion, or it may be in what is called elongation of any other ground available, as NAVG has correctly put it out, it may be the ultimate choice of the judge to decide whether the marriage is a failure and can be put to an end. What is your take on this?
No, I feel it should be a separate ground altogether. I feel the legislature should properly recognize the fact that there is a necessity and need for a separate ground, and introduce irretrievable breakdown as a separate ground, that should be made available to the parties, and which the parties can avail of essentially also because of the fact that, as Lordship said, there is no need to impute false allegations against each other. Where you really recognize the fact that you're no longer able to live together. So I feel it should be a separate ground.
Necessarily, it should be a separate ground available. Till such time, let us not say that there is no ground like that. Whatever is the available ground, the grounds already used should be interpreted to include this. When the Supreme Court has already used this and invoking Article 142.
And Vimala, my question is to you is, Supreme Court has been repeatedly saying that this is only available under Article 142. My take is, are not the high courts empowered to exercise the same jurisdiction under Article 226?
When the Supreme Court itself has said that Article 226 is wider than Article 32, and why High Court uses that power and to say that on the ends of justice, this is the essential thing, especially when the procedure under the Family Court Act contemplate that there should the Family Court should be able to bring an end to the dispute in a peaceful manner. Asking the parties after so many years of dispute, either we are not allowing them to live together because of the pendency of the case. When the case is pending for years together and we are ultimately dismissing it, where is the scope for the parties to live? They should live dead bodies inside a house.
And the prime youth is wasted on litigation and going to the courts, running between the pillar and post and advocate's office and other things.
Yeah, Mr. Srinivasaravan, you must also take into consideration the judgment of the Supreme Court in 2013, 6 CTC, page 560.
Yes, sir.
See, what is happening is Supreme Court has at least held 3 times that irretrievable breakdown of marriage is not a ground for divorce.
Yes, sir.
Unless the Marriage Act is amended
suitably.
Yes, that defect. So therefore, it says that the High Court can never grant a divorce on this ground. It is very categorical, it is very consistent. That is why we are saying that either the Supreme Court in a given case will have to elaborately read that into any of the available grounds, so that it will expand the horizons of the available grounds. Thereafter, it will be easy even for a family court to adopt it and pass a judgment to that effect.
Yes.
It is important that you have a precedent to that effect, or else either the Supreme Court or either the High Court, where the High Court judge is sitting on an appeal, it's possible that he can give an interpretation to it.
Yes, ma'am.
So until then, it will be very difficult for the family courts to adopt such a procedure. We are now talking about it, but how far it can be elaborated, etc. Because when it comes to cruelty, you will find that the bar is quite high. It is not that easy to place it on mental cruelty. So therefore, when it comes to that test, it becomes almost impossible to satisfy that requirement. If it is not, if it becomes difficult to satisfy that requirement, then reading irretrievable breakdown into it also becomes a problem. So I personally feel that it is important that the Honorable Supreme Court gives a judgment by expanding the horizon and reading this as a ground in any of the available grounds already available, so that it will set a precedent for the other subordinate courts to follow. It becomes very important.
Or else we need an amendment badly.
That's right. That's right.
Yes, sir. Ms. Jessie Jivapriya?
My question is, my lord, but if we take the ground of irretrievable breakdown, again, my lord, the standard of proof will be same like other ground. Then, my lord, again, my lord, counseling, then, my lord, evidence, my lord, it will go on again, my lord, it will take, my lord, the same time, 5 years or 10 years like that. So, my lord, if can we say, if this ground is included, prima facie, if the court come to a conclusion based on the pleadings, whether any interim relief may be granted to the parties. But because not if, like other grounds, if it take 5 or 10 years, then there is no use in including this.
You want divorce as an interim relief? Something very novel. Very novel, very innovative, and it may be disastrous also.
In fact, I would want to say one thing.
Then, like
Just
summary
to
trial.
clarify, just to clarify one thing. See, there is some in Kerala. There is something called as Marmakatayam.
Marmakatayam.
Earlier. In fact, there was a ground actually that was available like this. If after the filing of the petition, the parties were not able to get together or come together for 6 months, a divorce can be granted. In fact, it was available. So therefore, that's why I am saying today you can, the family court cases, every case has its own very peculiarities. So therefore, it's very difficult to define what would be irretrievable breakdown of marriage by giving it a specific definition. But there are some underlying rules to that, where the marriage is dead, where the emotional relationship has gone completely, where the parties have not seen eye to eye for years together. These are all some basic things which are already available. So therefore, these can be set as or kept as the ground rules, and from there the law has to develop. It's not fair on the part of the legislature to just shut itself up for the last 10 years. It was thought fit to bring this amendment. It was introduced in Rajya Sabha. It was passed. Thereafter, it did not go to Lok Sabha. It lapsed. For the last 10 years thereafter, no action has been taken. And what is now looming large in the society? The divorce proceedings is the one which is looming large in the society. What more is important than to have a legislation for this purpose in the act? So therefore, these are things which are very important, where such discussions will have to take place, and the people must be educated about it, and there should be awareness created about it. So every time a party who can afford to go up to Supreme Court 3 tiers and get a 142, how many can do it? 99% cannot even go there.
The family court can do one thing. They can have categorization of the cases, and the priority should be given to those cases where less time is needed for disposal. Like mutual consent cases, when irretrievable breakdown of marriage is taken as a ground, and if that is not seriously opposed by the other side, those cases can be disposed of very easily. Only categorization and prioritization is required. Just like any other case, every case is numbered, every case is put in a cold storage. That should not be if those grounds which do not give any scope for elaborate inquiry. Summary inquiry is enough for those cases.
Yeah, the family court judge should not irretrievably break down by the end of the case.
To put it in the what should be
very fine comment.
What should be this anyway, sir, what can be the broad-based consensus we have arrived at the end of this session? In your own words.
I think that all of us have unanimously agreed to the fact that it is high time that the parties, 2-3 things there is unanimity, at least I find. One is that the parties who get into a marital relationship must have an opportunity to have a peaceful exit from that relationship. True that mutual consent is available, but there may be situations where even today the decision is not being taken by the party and decisions are being taken by the parents of the girl or parents of the boy, etc. And they seem to be playing a major role in all these things. So what happens is that even if one of the parties wants to move out and the other party wants to stay, the issue is that there is pull and pressure from the parents, from elders, this and that. And by the time some conclusion is arrived at, it is 4 years, 5 years. So therefore, it's important that we should be able to have a ground where there is a peaceful exit from the relationship. That is number one. Number two, irretrievable breakdown of marriage was considered to be necessary not today. It was considered to be very, very essential in 1985 by the Supreme Court. And it was considered important even before that by the Law Commission in 1979 in the 71st report. So this is not something new about which we are talking today. This is something which was very, very essential and which was felt that it is important to have it as a ground in the Act from 1979 onwards until 2020. The legislature has not thought it fit to bring in at all. So we have unanimously also agreed that this irretrievable breakdown of marriage must surely find its place in the book. Three is that till that happens, it's important that there is a loud thinking on the part of the higher judiciary to give an interpretation to the existing grounds that are available by reading this irretrievable breakdown of marriage into those available grounds. I think broadly these are the three things over which I think there is a consensus of all the three of us in the panel.
I thank all the three panelists for the what is called the most elaborate and meaningful discussion. And I thank this Vimala and the young blood Gopika for their meaningful contribution, and the NABJ as usual with your exuberance lecture, sir. Thanks, one and all. Thank you, sir. Thank you very much.
Thank you so much.
Thank you, sir.
Thank you, sir.
Okay, thank you.